This July, Dr. Valerie Williams saw a patient whose water had broken at 16 weeks, making it impossible to continue the pregnancy to viability. The hospital's lawyer nonetheless said she could not intervene. Louisiana's near-total abortion ban had just gone into effect. In Dr. Williams's words, going back into that hospital room and telling the patient that she would have to be induced and push out the fetus was one of the hardest conversations I've ever had. The patient screamed for hours from the trauma of pregnancy loss. She began hemorrhaging and lost close to 1 liter of blood before Dr. Williams could staunch the bleeding. Over a decade ago, I wrote an article that began with a similar story recounted to Lori Friedman, whose work all of you should read about Catholic hospitals, who interviewed a physician at a Catholic hospital who saw a patient 19 weeks pregnant and miscarrying. Catholic hospitals ban most abortions and an array of other reproductive care. Prevented by the hospital policy from intervening, Dr. Schmidt saw his patient become septic with 106-degree fever and profuse bleeding. As the patient was dying before our eyes, he performed the abortion, contrary to hospital policy and order. The patient suffered permanent injuries, and horrified, he quit, saying, "I just can't do this. This is not worth it to me." So-called conscience legislation, I argued, had created this conflict between individual conscience and institutional policy and produced an unjustifiable asymmetry in the treatment of conscience in medicine. Doctors and nurses who would not participate in abortion and tubal ligation or comply with advanced directives for end-of-life care could refuse without consequence. Employers had to accommodate them. States couldn't discipline them. By contrast, doctors and nurses committed to delivering care as a matter of conscience were without legal protection. They could be fired by employers with refusal policies, and as came up earlier today, in many states, providers committed to abortion care had to comply with biased informed consent scripts, subject their patients to waiting periods that increased cost and risk, and perform unnecessary and intrusive ultrasounds. If they breached those legal bounds, they could face criminal charges and disciplinary proceedings. And this was so even though these willing doctors and nurses had equal claims to exercise their conscience. Likewise, under state and federal laws passed after Roe v. Wade, only when an institution refuses to deliver legal, necessary care did the law recognize a concept of institutional conscience. In refusing hospitals, staffs of all faith, beliefs, and backgrounds had to fall in line. At the same time, institutions willing to deliver abortions or other care had to make room for individual objectors. Now, one might think that the overruling of Roe will make issues of conscience in medicine less significant. After all, it was the constitutionalization of the abortion right that first prompted legislatures to safeguard conscientious objectors. Now that abortion is banned in many states, the conscience issue might fade away. I'm going to argue that to the contrary, with the demise of Roe, the asymmetry in the legal treatment of the consciences of willing and refusing providers will deepen and conflicts multiply. Under red state abortion bans, a large share of providers will effectively find themselves subject to the same sorts of restrictions that Catholic and refusing hospitals previously imposed. Crises of conscience will develop beyond OBGYN and emergency medicine in oncology, intensive care, dermatology, and beyond. But by contrast to the legislative response to Roe, the consciences of these providers will elicit no concern from state legislatures. Instead, refusal laws will grow. Following the playbook most successfully deployed with regard to abortion, politicians will authorize refusal of a wider range of services and permit institutions to impose restrictions onto physicians. And these will set up further collisions between willing providers and the institutions where they work. Beyond red states the tentacular reach of religious healthcare systems with numerous rules against standard of care reproductive services will reach an ever greater number of individual providers. Many blue states have allowed their healthcare markets to become dominated by, in particular, Catholic health systems to the detriment of public policy goals. While these states have some policy and legal tools still at their disposal, they likely will find that federal conscience laws or constitutional free exercise challenges will pose a barrier. So I'm going to begin just briefly by setting out the argument that provision of abortion and other care can be conscience-based so as to explain why the asymmetry in legal treatment is unjustified, before I turn to the landscape in red states and then blue states, and then perhaps get to some complications, I think, that will probably emerge here, and maybe make the legal landscape so unstable that we finally see conscience legislation for exactly what it is. So drawing on my previous writing, I just want to briefly make the case that conscience can motivate provision and is equally deserving of value, so that if state legislatures, scholars, and the public actually seek to protect conscience, they have to weigh these claims equally. And some of this ground has been trod before, so I may jump around a little with some choppy transitions. But so suffice it to say that I'll broadly adopt an accepted definition of conscience as human knowledge of right and wrong, our moral consciousness, our process of moral decision making. It's not a mechanical application of a rule, but rather a process by which a person identifies moral principles, assesses context, and decides whether to pursue or omit action. So conscience compels action or withholding of action. And we can disagree over fundamental questions of right and wrong. Every person is capable of conscience, which doesn't mean that most of us exercise our conscience all that frequently. We know some people are more conscientious than others. I do want to clear some brush, I think, that may be developed earlier in our discussions. So when we talk about conscience, yes, we talk about moral integrity. That goes to the question of, why do I care about your conscience? It makes sense that I care about mine. Mine is right. Mine is infallible. Yours, on the other hand, well, I care about yours because I care about people. And I don't want people walking around in constant moral distress. And I don't want people making martyrs of themselves. So conscience, and what we've been talking about in terms of conscience, is not selfishness. It's not self-centered. It's actually usually other-facing, right? It's not that I won't fight in a war and kill people because I care about myself, I'm selfish, I prefer to watch TV. It's rather that no matter what you do to me, I won't kill someone, right? That's a separate statement. It's a different statement. And so even though you think that I'm wrong on warfare, you still might say, I don't want to have to martyr her, right? But you still want to obtain your public policy goals, so that's going to be important if you're thinking about when to accommodate conscience. But it's not about selfishness. The other thing I want to note when we're talking about conscience, which sort of came up at the margins of the last panel, has to do with where conscience comes from. So conscience can have a lot of different roots, right? For people who have religious faith, often religion is one of the inputs into their conscience. It may shape what they view as morally right and wrong. But religion has no monopoly on conscience. Indeed, professional ethics represents an important source of conscience for healthcare providers. And this is why, contrary to what Professor Smith said earlier today, conscience is not unbounded when we're talking about medicine. In fact, when we are talking about conscience in medicine, we have traditionally tended not to talk about purely idiosyncratic or subjective acts of conscience, not Jesus made me do it, not Fox News told me this treatment worked, but rather a claim about life and death, a claim about obligations of doing no harm or preserving life. That is, issues on which there can be good faith disagreement between physicians about their roles as physicians. The second point to note, which also came up at the margins of the last talk, is that refusal of care is rarely conscientious or even motivated by religion. Around 85% of OB-GYNs do not perform abortions, and it is largely for reasons of the danger and politics and non-lucrative or even boring, some would say, nature of abortion provision. The flip side, which was also hinted at in Dr. Modi's presentation, is that much provision of abortion care can be seen as strongly sincere or perhaps conscientious because it is delivered under threat of severe sanction. People face stigma and exclusion, which is not to say all abortion care or all provision of care can be viewed in that way. But I think it's important to note that when we talk about conscience in medicine, we're not talking about simple refusal or simple provision. We are talking about rather identifying moral principles, assessing context, and deciding whether to act, not the unthinking application of rules. Okay, so why do we say that abortion or that other care could be motivated by conscience? Well, just as someone may think to their deep moral principles, deeply felt moral, ethical, or religious values as they confront particular patients and determine that it would be wrong to provide care, so too do providers go through this process and conclude that they must provide care to a particular patient. Some nurses might invoke their religious beliefs in favor of withholding care and indicate God would not want patients to suffer the way that they do. Others explain their participation in physician aid in dying in quite similar terms. Now, some make, in the abortion context, a common objection that there's a moral distinction between being compelled to do and being compelled to refrain. So maybe legislatures should be more concerned about refusal, and that's what motivates the asymmetry. But as Mark Whitclair has argued, one's moral integrity can be damaged by either performing an action that is contrary to one's core ethical beliefs or failing to perform an action that is required by those beliefs. And our law and religion doctrine in the United States has thought about burdens on free exercise in this way. It doesn't distinguish between acts and omissions. And in medicine in particular, distinguishing between act and omission doesn't work for two reasons. First of all, the lines are not always clear, right? An off-cited example is stopping a respirator. Does the doctor omit continuing treatment? Or does she act to disconnect the machine? Another example might involve ectopic pregnancy and its treatment. And here, looking to Catholic healthcare institutions for a model of what we might see, right? The standard of care, typical treatment for ectopic pregnancies will be the administration of methotrexate. Many Catholic hospitals limit the treatment of ectopic pregnancies in this way, and instead require the removal of the fallopian tube where the embryo has implanted. So when a physician ends the ectopic pregnancy, are they acting or omitting, right? Are they omitting to go along with the policy and take out the fallopian tube? Or are they being required to act in that way? You can see how the line between omission and act isn't clear. The second basic reason that act-omission distinctions in medicine don't really work is because moral responsibility is a function of the role-specific obligations of healthcare providers to patients. So that a doctor who unilaterally omits to deliver CPR to a patient is considered morally responsible. Another who does not inform a patient of a fetal anomaly during a pregnancy is morally responsible, whether we consider her to actively harm or to simply allow the harm. To put it in the specific context of abortion, take a pregnant woman miscarrying with no chance of fetal viability and faced with suffering grievous harm if left untreated. A refusing doctor might claim he cannot be forced to perform an abortion and must wait for fetal cardiac activity to stop. A willing provider, by contrast, might claim he cannot be compelled to make the woman suffer and risk death. Both providers agree on the sanctity of life, and the effects on their consciences are the same if the institution says, no, you may not do what you wish to do. And this is regardless of whether we construct their claims, and we can flip either of them to be built around act or around omission. So to the extent that conscience legislation is a means, as we've heard, to moral integrity, to pluralism, to avoidance of moral distress, to the encouragement of ethical engagement, all these values would seem to favor treating conscientious commitment equally. Now, as to so-called institutional conscience, I'll just say that artificial entities, hospitals, doctors' offices, cannot exercise conscience. It is a function of being a human being. And the value of moral integrity, the self, it doesn't translate to a corporate context. Now, protection of religious institutions, of refusing institutions even, might reflect other values. It might reflect values in associations of individuals or in the pursuit of moral ends separate from the state. These are values worth considering and perhaps protecting. But when we talk about institutional conscience, we lose sight of those values, so we fail to think, are hospitals really places of moral association? And in any case, institutions that provide care have equal claim to the label of institutional conscience. They too may unite people behind a specific central purpose. They equally may implement rules important to their mission. And yet, as Professor Sawicki described, we have asymmetric legal treatment here across the board. Okay, so what does this mean for the red states? Well, in red states, we're going to see more pronounced asymmetry. I think the legal landscape will look more hostile to conscientious provision and still more accommodating of refusal, whether conscientious or not. So to state the obvious, abortion bans oppress conscientious provision. In states banning abortion, all physicians will experience the sorts of policies, scrutiny, and surveillance that once was limited to their colleagues in refusing hospitals. And individuals from a variety of medical specialties will feel the constraint. They are feeling the constraint in states like Texas. Oncologists find their hands tied before pregnant cancer patients. In the NICU, doctors and parents are being required to intensively treat infants born too early or with severe fetal anomalies inconsistent with any maintenance of life, rather than being able to offer comfort care. There are myriad stories from a variety of specialties. Now, one thing to note about this is that providers in Catholic and other refusing hospitals seem likely also to find increasingly that they are in situations where refusal of patient care challenges their consciences. And this is because willing hospitals and providers always offered a release valve. Where an ethics committee or an institutional actor within a Catholic hospital refused, say, to permit ectopic pregnancy treatment or miscarriage management, a physician could transfer the patient, at least in theory. Now the closest hospitals able to provide abortions in states like mine will be hundreds of miles distant. and pressure will mount on physicians in these institutions in new and unprecedented ways. So while I think Catholic hospitals and the variety of restrictions they have are a model for understanding what's happening now, in some ways we are in unprecedented territory because there used to be some measure of alternative. Now, as states move to ban standard of care treatment, whether for abortion or for gender-affirming care, which I hope I can talk about a little bit more in a second, one might think that the conflict reduces to state versus provider. And certainly the consequences now of providing some of this care are extreme in terms of criminal charges. But institutions are going to play a key role, right? In surveillance, control, and reporting. And we know this from Catholic healthcare. The treatment of physicians in some, this is not a story of all, there's a lot of variance between different Catholic healthcare settings, but the treatment of physicians in some Catholic hospitals serves as a cautionary tale. Nurses frequently police doctors. There are reports of procedures made to ethics committees with allegations that they are violating religious rules. Already we've seen healthcare entities move to further constrain providers beyond the bounds of law. And let's be reminded, Hannah Arendt reminded us of what happens when we do the work of fascists before they make us. And this is part of the story, right? We've seen institutions determined to prohibit emergency contraception under abortion bans that did not apply to that care. Major pharmacy chains have refused to dispense methotrexate for any purpose, requiring special information from patients and physicians. We've seen children's hospitals shut down gender-affirming care in the face in Texas of an unenforceable gubernatorial order. And I want to note a change in the hospital market. Before Roe, many doctors had their own solo practices. You know, the sorts of things that people are talking about, urging physicians to do, quiet non-compliance or law-breaking, that was a lot more possible when it was a single physician in an office before people regularly had insurance that was being billed and regularly surveilling what physicians were doing. That's before hospitals were buying up physicians' offices. It's before physicians were practicing in large group practices. We simply don't have that kind of labor autonomy that doctors had in the period pre-Roe. So in red states, even as willing providers, treatment under the law is going to remain the same. And just let me give you one piece of evidence, right, that we already have. Consider that in passing an SB 8-style bounty hunter provision banning abortion, Oklahoma specifically exempted the statute from its Religious Freedom Restoration Act. Why did it do that? Because it was afraid that providers that had religious beliefs and pregnant people that had religious beliefs would be able to use their religious freedom in defense of a lawsuit. They're not going to be granting conscientious objector provisions for those who object to abortion bans. And refusal, meanwhile, will run wild. There's been rising interest in expanding the interpretation and the reach of refusal laws. A raft of new conscience bills is being proposed and have already passed in the last year in Ohio, Arkansas, and now South Carolina. And these are jaw-droppingly broad. They apply to all healthcare services, including diagnosis, prognosis, referral, and administrative activities like record keeping. Jehovah's Witness nurses could refuse to transfuse patients. A vegan could withhold vaccines that contain egg proteins. But more likely, psychologists could refuse to see patients with gender dysphoria. Nurses will deny HPV vaccines. Administrative staff will fail to schedule STI testing. And this newest iteration of conscience legislation creates even more absolute rights and resulting duties of accommodation on willing institutions. So Oklahoma, for example, has proposed a bill that would move from a duty to reasonably accommodate objecting providers to an absolute duty to accommodate employees. And the language of these bills provides this absolute duty even in emergencies. So you can imagine, and I've heard stories throughout my years of doing this work, right, of the difficulty of finding anesthesiologists, for instance, willing to staff DNCs. Now, in an emergency, someone couldn't refuse without facing some sort of repercussions from the institution in most places. Under these new bills, there is no restraint on the accommodation that an objector would be owed, at least in the model bills being proposed, and they're being proposed in lots of states. So what's the goal here? Well, again, Professor Sawicki set me up nicely, right? She put up a number of laws that apply to healthcare settings. And it's these laws that are going to be the targets. It's about obligations of emergency abortion care. It's going to be about emergency contraception in states that preserve this by law. It's going to be about LGBTQ affirming care, perhaps more than anything else. And what this tells us, right, the asymmetric treatment of conscience makes a lot of sense once we understand that these laws were never about conscience at all. And indeed, many of them have long read it merely in the language of refusal rather than conscience. And following the abortion playbook, these new series of laws will foster refusal, not conscientious engagement, which we might want to see more of from the medical profession. So they'll encourage refusal of contraception, transgender care, perhaps drugs like methotrexate for other indications. And as we saw in abortion, these laws will probably ossify and spread misunderstanding of science. It will probably also work to delegitimize standard of care medical practice as it has with regard to abortion. And it will, as I think has been manifested today, create the problem of painting all refusal as though it were motivated by moral, religious, or conscientious values, when most of it is not. So that's what we'll see in red states, and I'm going to just take maybe 5 minutes and to say what we'll see in blue states. Now, I think unfortunately what we'll see in blue states is that the divergence between red and blue will not be as stark as we will imagine, that we will see red and purple. And why is this? Well, in a number of places where abortion remains legal or less restricted, the existing share of religious institutions is going to create choke points on access. So as a result, even with state guarantees of liberal abortion laws, access will prove elusive for a number of people. So the reality is that in particularly the Pacific Northwest and much of the Midwest, Catholic hospitals dominate many markets, and they restrict a long list of reproductive and end-of-life care. And these institutional refusals in particular have shrunken access to reproductive care across the country. Refusal of abortion care in particular is common, with above 90% of hospitals offering no non-therapeutic abortions. And the definition of a therapeutic abortion actually is quite narrow, excluding situations most lay people would view as emergent, or at least urgent. And access to tubal ligations is already quite restricted due to Catholic healthcare in the Northwest and the Midwest. And the situation seems to be worsening for 3 reasons. First, healthcare systems across the board, but including those with lots of religious restrictions, are rolling up physician practices, which I referred to earlier. But the shift from an independent group practice to a hospital-owned practice group, or from self-employment to employment status, basically permits institutional actors to exert a great deal more control and to extend restrictions from the hospital setting into physicians' offices everywhere. And this is going to matter because with abortion bans in place, it becomes much more important, as we heard earlier, for people of reproductive age capable of becoming pregnant to avoid those pregnancies. And the restrictions in Catholic healthcare in particular extend to things like IUDs, to regular oral contraception, and to, of course, tubal ligation, as we heard. The second reason we're going to see these things extend and the market conditions be difficult in blue states is because there's quite a bit of horizontal merger and partnership activity. And I have other papers on this topic, but Catholic healthcare institutions have negotiated for religious compliance as part of hospital sales, joint ventures, operating agreements. So we have secular hospitals. We have hospitals affiliated with pro-choice religions. We have government hospitals that comply with Catholic healthcare and restrictions. So you can go to a hospital that says Baptist hospital or Jewish hospital or Presbyterian hospital. They are complying with Catholic restrictions on care. And when Catholic hospitals are sold, now California has a good law on this, but in other states when they're sold, they often maintain their Catholic restrictions, so no matter who the buyer is. So we have for-profit, private equity-owned hospitals that are designated Catholic hospitals. Third, and relatedly, the U.S. Conference of Catholic Bishops has become much more stringent in their interpretation of Catholic doctrine. And so this is fueling the level of restrictions and the stringency with which they apply. I'm going to skip over the obstacles and leave you with a tiny bit of hope insofar as hope lies in anarchy, which is what I'd like to suggest. In red states, right, that are adopting these really wide-ranging refusal laws, guess who's going to qualify? Conscientious providers. They are going to be the new refusers, and it can't apply to all things probably, but the definitions of refusal are so broad that I can imagine turning a conscientious provider into a conscientious refuser, sometimes at the margin, sometimes squarely. So squarely, a healthcare system says, sorry, in this hospital, we misgender patients. We do not provide gender-affirming care. So they say, you must misgender. You must do talk therapy and prescribe antidepressants if someone comes to you and says that they're transgender. Well, I refuse to do that, right? I am going to call someone by their proper pronouns. I am going to prescribe them hormone blockers in place of antidepressants. At the margins, right, when a physician in the ER sees a patient miscarrying, right, the hospital says, discharge them to home, right, premature. Discharge them to home, pre-viability. And the doctor says, no, I refuse. I refuse to discharge them, right? And so we see refusal. Now, and my last point is I think we have some liberatory potential in institutions. I think that institutions have been overstepping. They're going beyond. They are proving additional points of oppression, even as the state is oppressing providers. There's some potential for them instead to work to shield providers, to use ethics processes in ways that grant maximum freedom for conscience and for patient care. And I think at some point, traditionally refusing institutions are going to run into the abortion bans. Baptist hospitals, for instance, restrict some, but not all abortions, right? And there are states now, states like Idaho, total abortion ban. There is no life-saving exemption. You have to be charged with a crime and then affirmatively prove that you acted to save someone's life. I think a Baptist hospital, if charged under this law, could make a good claim that, in fact, their religion required them to provide the abortion in that circumstance, that the exception, well, there is no exception in Idaho, it was too narrow, right, that they had to act to prevent health. Anyway, these may all be fever dreams of a law professor, but I think there may be some hope of collapse or at least exposure of what's really going on. When we talk about conscience in medicine in state legislatures, we're usually talking about refusal of reproductive and gender-affirming care. We're not talking about conscience. Thank you.
Thank you very much. I'd now like to turn the microphone over to Professor Rothstein for some comments.
Well, thank you. I want to commend Professor Sepper on just a wonderful presentation, although I have to say I have heard cheerier, more uplifting talks in my life. One of the points that she makes in her writing, and just talked about it briefly here, is the notion of conscience creep. And that basically refers to expanding refusal laws and private policies to include more prohibited procedures and services, as well as extending their applicability beyond physicians, nurses, pharmacists, and others to cover administrative and support personnel. I agree with this notion that conscience creep is part of a broader trend. I believe that in some cases, the invocation of conscience is an effort to cloak libertarian political philosophy in religious doctrines and thereby invoke the First Amendment's Free Exercise Clause, Title VII's religious non-discrimination provisions, and other legal protections. And the Supreme Court's willingness to entertain increasingly forceful religious liberty claims, I think, has encouraged this spread of conscience claims in various settings. As applied to healthcare, excessive reliance on conscience, including conscience based on religion, can have disastrous consequences for individual and public health. One need only consider the effect of politically inspired claims of religious exemption from public health measures during the COVID pandemic. Despite strong support for vaccination from religious leaders of virtually all religions in the United States, including from Pope Francis, widespread opposition to COVID vaccination based on so-called conscience resulted in hundreds of thousands of unnecessary deaths. One possible way to mitigate the use of conscience clauses by healthcare institutions is to apply principles from employment law and medical ethics. Here's how that might work. Employment law prohibits wrongful discharge based on public policy, and this might permit some health professionals to invoke conscience-based rights to provide medically appropriate health care, even if it diverges from restrictive institutional policies. The public policy justification, which you need to have one of these claims, would be that failure to provide the care would violate medical ethics, and I'll talk about that in a minute. So one example where this would arise is where you have a willing healthcare provider practicing in a state where abortion is legal, but at a hospital or other institution that prohibits it. In such a situation, the provider arguably has a legal right not to be discharged for performing abortions or providing other lawful medical services. I think one of the things that is often missing from the discussion of this issue is that neither a conscience-based refusal by an individual nor institutional policies restricting medical procedures preempts the professional responsibilities of physicians. According to the Code of Medical Ethics of the AMA, the invocation of a conscience clause requires 3 essential protections for patients. First, physicians should, quote, uphold standards of informed consent and inform the patient about all relevant options for treatment, including options to which the physician morally objects, end quote. I would add that all medical options should be presented to the patient in an objective, non-judgmental, non-directive, and respectful manner. Second, declining to provide treatment based on a physician's conscience may not be appropriate, quote, when there is imminent risk of foreseeable harm to the patient or delay in access to treatment would significantly adversely affect the patient's physical or emotional well-being, end quote. Third, physicians should, quote, refer a patient to another physician or institution to provide treatment the physician declines to offer, but if the patient is not reasonably able to access needed treatment from another qualified physician, the physician's moral concerns should yield to the professional obligation and duty of fidelity to the patients. The code of ethics notwithstanding, as Professor Sepper and others today have observed, the reality is that a healthcare provider's conscience and institutional policies typically have overridden any concerns about professional obligation. Moreover, claims of conscience include a broad range of political, social, and personal motivation. New medical practice arrangements also play an important part in the exercise of conscience. According to the AMA, in 2020, only 17% of physicians were in solo practice. The Marcus Welby myth of a kindly neighborhood physician with a home office who also makes house calls is a relic of the past. Instead, physicians are increasingly employed by large multi-specialty groups and hospital-owned medical practices, and also work as hospitalists, a trend some observers believe has increased during the pandemic. Physician employees of a larger organization often have little control over institutional policies, but they might be protected by employment law doctrines if their employer requires them to violate professional ethics. Here's how that would play out. All employees without contracts for a fixed term are considered at-will employees who may be discharged for any lawful reason. This was a 19th century doctrine, and it became the law in every state until the second half of the 20th century. In 1959, in Peterman versus International Brotherhood of Teamsters, a California case, the employer ordered an at-will employee to testify falsely at a legislative hearing and then fired the employee when he refused. The California Court of Appeals held that the employer's conduct violated the state's public policy of encouraging truthful testimony and therefore was an abuse of the employer's right to fire at will. This public policy exception that began in Peterman is now the law in 43 states and the District of Columbia. Professional codes of conduct have been recognized as a source of public policy by courts in a limited number of cases, the most instructive of which is Lopresti versus Rutland Regional Health Services. The plaintiff in the case, Dr. Lopresti, worked for the Physician Group, a very cleverly named organization, a multi-specialty group practice in Rutland, Vermont. As a primary care physician, Dr. Lopresti often had to refer patients to specialists, but he developed concerns about the quality of care some of his patients were receiving from 3 physician group specialists, including performing unnecessary procedures, hospitalizing patients unnecessarily, and providing substandard care that caused harm to his patients. After he stopped referring patients to these 3 specialists in his group, he was terminated by his employer, the physician group. The Supreme Court of Vermont, recognizing the viability of Dr. Lopresti's wrongful discharge claim, stated, quote, assuming he can prove these allegations, the enforcement of public policy here would have a tangible connection to the protection of health consumers. Therefore, Dr. Lopresti's claim is consistent with our view that compelling public policy is intended to prevent injuries to the public, especially in matters of public health. Although the Lopresti case is a minority view, courts receptive to the argument that public policy can be based on medical codes of ethics can find a wealth of sources in AMA documents and the pronouncements of various specialty colleges and societies, including the American College of Obstetricians and Gynecologists. What would the opponents of my argument say? I think they would ask, what about the rights of healthcare institutions? In my view, healthcare institutions, including those with religious affiliations, are public institutions in the broadest sense. They almost always receive federal financial payments from Medicare, Medicaid, and other government sources, obtain state and local tax exemptions, get public credentialing of the institution and its personnel, and most importantly, perform an indispensable public function. Increasingly, a religiously affiliated hospital may be the only hospital in a large geographic area. These institutions owe their very existence and their obligations to the public. Religious healthcare facilities should be free to accommodate the consciences of their personnel and to advance the institution's religious mission, but they should not be able to impose their moral values on the public to prevent medical care that is legal in the state where they are located. Before moving to San Diego this summer, I was a professor at the law and medical schools of the University of Louisville, which is a state university. In 2013, the University of Louisville Hospital, the city's only public hospital, was acquired by Kentucky One Health, an entity created by Catholic Health Initiatives, an organization with over 100 Catholic hospitals and clinics in 18 states. At the time of the sale, to accommodate the religious mission of Catholic Health Initiatives and the public responsibilities of University Hospital, the Center for Women and Infants, a separate facility located within the hospital, was created and operated under the sole direction of the University of Louisville. So within this Catholic hospital, there was a separate institution that was created, the Center for Women and Infants. And the reason was so that it could continue to provide comprehensive reproductive health services, including to indigent patients. Although the University of Louisville Hospital was later repurchased by the state, the carve-out for reproductive health in the prior purchase agreement, I think, is very instructive. I believe it is possible to balance the religious missions and public responsibilities of healthcare institutions, but there must be a recognition of the need to do so and a willingness to do so. In my view, creative, respectful resolution of conscience issues is possible if done in good faith. Thank you.
Thank you very much. So we're going to turn to questions. I see Dub would like to.
Oh, those were so good. Thank you both very, very much. I have a quick question for each of you. First, Professor Sepper, how would you respond to someone who shares your larger goal of promoting public health and making accessible a wide range of services, who says, but the Catholic institutions are the ones that are providing care generally. They have the money to buy the hospitals, to hire the staff, to do this, and that if you are right and they are forced to provide services that they don't want to, well, then they'll take their ball and go home, and we will be left with fewer facilities and less care, all things considered, or overall, or across the system. For Professor Rothstein, my question is about the carve-out you mentioned. This may be, small circle within the larger sectarian institution that they might frown upon, but nevertheless enabled by way of compromise. How would you respond to an institution that says there can be no compromise when what is being done in the frowned upon wing, the basement, or this, special maternal fetal area is tantamount to murder in our view? How can we compromise there? What space is there to accommodate something that we regard in that way.
So yeah, thanks for that. Okay, so I think health economics offers the answer to the question, could they take their ball and go home? It's not their ball. That's more or less the answer, right? So the way nonprofit, okay, first of all, the Catholic Church does not own the assets of Catholic healthcare institutions. And nonprofits don't have owners. Right, whereas shareholders are owners of an institution, nonprofits, which most Catholic healthcare is, has members. These are essentially people who serve on the board of directors. But they don't, they're not the owners, right? Nonprofits are complex in that they have charitable purposes, they have community responsibilities, and the term community hospital is one that actually was fostered by nonprofits, but we should remember that that means they have responsibilities to us, and there's even been discussions that we as communities own community hospitals. So there is no ball to take home. When nonprofits close their doors, say that you no longer have a hospital anymore, that money, whatever's left after they pay creditors, goes into a charitable trust for a foundation, usually a foundation devoted to healthcare mission, right? So there isn't a ball to take home. So if these institutions, which most of them are economically viable hospital institutions, then whether they have a sign that says Catholic or not is not going to change that. And that's what we've seen, right? Dignity Healthcare here in California. Well, we saw this with St. Joseph in Phoenix, Arizona, where due to a dispute that arose based on an emergency abortion, a woman religious running the hospital was excommunicated by the local bishop. And what happened? The hospital is no longer Catholic. Now, are the people all the same? Is the institution the same? Even the owner's the same, Dignity. So Dignity started running some Catholic hospitals as full Catholic hospitals and others with only certain religious restrictions in place or the same name on the building, right? Otherwise, nothing changed. So we at least have some examples that this is right. Now, the problem is that in an individual situation, so where you have a single hospital, it's much easier to convince the public that if the owner closes shop, it leaves, especially if it's a sort of hospital that's within an area that's economically depressed, rural hospitals, sole community hospitals. But I don't think we should accept the premise. Instead, we should back up and think, where do we need hospitals? What kind of care do we need? And how do we serve the public? Now, this is not necessarily where our politics is, but but the beauty of healthcare is there's politics at local, state, and national levels that can inform where we situate hospitals and what kind of support they get or don't.
So, Dov, on your question, is my example valuable for other institutions? And I have no illusions that this is going to be trotted out elsewhere. All that I think is that we need to just not give up totally the notion that nothing can be done. And I was involved to a degree in this takeover. It was very interesting because at the same time the Catholic Health Initiatives purchased University Hospital, they also purchased Jewish Hospital in Louisville. So Jewish Hospital was a Catholic hospital. And there are other issues that were raised by that. I think I'm not an expert on how the Catholic Church has evolved over the last 10 years with regard to its views on all these issues. It may be totally impossible to do something like this now, but I just, it's too important to just say it's this or it's this and we can't do anything. And I think people of goodwill and who are reasonable need to sit down and try to figure out what the heck they can do.
Back there.
Thank you for those talks. That was really fascinating. I have a question, I guess either of you could answer, is just when you were talking about these Catholic institutions and the responsibilities for the public, I wonder if you think, this line of argument might work to say that they are actually fiduciaries for the public. So it is possible to be a fiduciary for the public. If you're a trustee of with a public trust, for example, you're a fiduciary to the public. I actually argue in my book that physicians are not just fiduciaries to individual patients, but to the public as a whole. And it's also possible for institutions to be fiduciaries, like the Government of Canada has been deemed a fiduciary for Indigenous peoples in Canada. So I just wonder whether that might be, a line of argument that, you'd possibly be interested in pursuing.
Well, I think it's you've persuaded me, but I think it's more of a political argument than a legal argument at this point. And if it's part of some agenda that you could make for policymakers, then let's trot it out. But there's no doctrine that I'm aware of that could be applicable right now.
So, I think my reaction is somewhat similar. I think whether we're reviving old ways of talking or new ways of talking, and thereby thinking differently about our healthcare system, I think it's valuable. There's talk, in the 1970s, there was a lot of talk about treating hospitals as public utilities. They provide necessary goods that everyone needs. People need different amounts at different times. They need them when they need them delivered to them. And there was a lot of talk there. In fact, there was a lot of suggestion that we might nationalize a number of hospitals. That didn't really end up happening. Thank you, President Reagan. Right? We had a real shift in our politics, but maybe there's opportunities to think differently. And I will say, on the history of Catholic hospitals is that, one, they have always been responsive to political demands. They can read the political situation pretty well. They're reading it a certain way right now. But if the political situation changes, then they'll read it differently. And I'll also say, just to give support to the idea that provision can be conscientious. Before Vatican II, throughout the 20th century, Catholic healthcare administrators, as well as members of the hierarchy they were dealing with, routinely talked about the importance of allowing physicians to treat patients consistent with conscience. And, even in the 1800s, Catholic hospitals advertised that they were respectful of all patients' consciences and creeds. And so there's always been a sense in which sectarian institutions engaged in secular enterprises that the public needs do recognize they're not engaging in religious association when they're treating patients in community.
I just want to add briefly that after the takeover of Jewish Hospital by the Catholic Health Initiatives, I remained a member of the ethics committee where I was on for probably 17 or 18 years. And Jewish Hospital had no obstetrics department, so that took care of a lot of problems. Everyone was concerned before the merger about the end-of-life care. And on the ethics committee, there were several priests, and I served probably 2 or 3 years on the committee after it became affiliated with the CHI. We did not have a single incident or case that I can recall where there was a problem in terms of end-of-life care. But as I said before, I don't know whether things have changed and whether that would be the case today or whether it would be the case in a different part of the country or whatever. I was very pleasantly surprised because I thought that would be really the sticking point in terms of the ethical issues. We had no problems with that.
Thank you. Is this on? No. Can you all hear me? No. Okay, thanks. Okay. Thanks very much for both of your talks. Professor Sepper, you said at some point, and I'm very sympathetic with everything you've said, but you said at one point that hope lies in anarchy. This was at the end of the talk. And I couldn't quite tell because you were smiling when you said it, and I wasn't sure whether it was tongue-in-cheek or whether you really meant it seriously. If you possibly meant it seriously, I have some concerns, right? Just as I have concerns about, so suppose you watch SB 8 happen, right, in a state having to do with abortion, and then a blue state looks at this and says, well, I'll SB 8 you on gun control, and then other states go and SB 8, on something else, and so now you've got, instead of like opposing SB 8 as a way of handling things, it's just all the states are now SB 8ing each other. Now, we do the same thing in the case of conscience. So you got conscience, you've got conscientious refusal for X, you have conscientious refusal for Y. And so is it really the case that you want to recommend that there be anarchy so that now there's conscientious refusal for Z and for W and for everything else over in these other states? And because at the end of the day, this kind of strategy, if brought, completely general, just destroys the rule of law. I mean, this is something I'll be saying later, but I'm worried about this.
Okay, so, yes, I was being tongue-in-cheek in some sense, but anarchy's already here, right? So there's a number of states, and there are something like 20 bills being proposed for 2023 state legislative terms that plan to broaden conscientious refusal laws in a number of different ways, including allowing refusal of virtually anything in any stage of patient care, including record keeping, scheduling, et cetera. Okay, so to my mind, anarchy's already here. So what does that mean? Well, what we've seen in the past, I think, in my other area I work in a lot, law and religion, right? We've seen a sort of unilateral disarmament, right? So there's a ceding of the ground. It's that religion is necessarily anti-choice. It's necessarily anti-contraception. That religion is something of conservatives, for instance. And conscience has seen a similar phenomenon, and a similar phenomenon in that refusal, I mean, a lot of these laws, even from the early 70s, use the language merely of refusal. They often had the titular language of conscience, but it simply said refusal. And it just seems to me that we lost something in not calling that out for what it was, right? But as laws expand, if a law says that you can refuse any medical service, I don't see why you shouldn't. If you are someone committed to delivering certain categories of care, why you shouldn't refuse institutional instruction to treat a patient in a way that you think violates good medical care. In fact, I think you probably should do exactly that. I have major concerns, not at the level necessarily of the rule of law, but rather at the level of anti-establishment, which I think is at a certain point, if you allow religious refusals to grow, or even if we call them conscience, often I think we just call them refusal in these laws, but if we allow them to grow, we are actually encouraging everyone to claim religion, which is an establishment problem in that the state puts the thumb on the scale for religious people and not for non-religious people. So I think that's a real downside. And I had more to say, but I already went on more than long enough. But I think that is actually a real problem. But I think that to the extent we're seeing this legislation grow, then we need to see institutions like Jewish hospital, right, claim the mantle of religiosity and use it in the other direction to foster access to care, because I don't see a lot of other options. And I think it might convince, right-wing forces to move away from the language of religion and conscience. I actually think it's really bad for religion and conscience to dress up what are ideological commitments in the language of Christianity. I think that's bad for Christianity.
Thank you.
Thanks. Are there other questions? Well, people. Oh, sorry. There's one right at the back. Yeah. Thank you.
Can I ask you a quick question?
Sure.
Do you think there's any role for healthcare worker unionization? I haven't been following very closely, but I know there's been some talk about physicians unionizing in some places for the first time, at least in a long time.
There have been talks about that for probably 30 or 40 years, and I think it's a long shot. It would be almost as hard to unionize lawyers as docs.
Please go ahead.
Okay, thank you. My name is Father Sylvester. I'm a Catholic priest. And I have heard all of the good things you have said about the Catholic Church and her role, especially in healthcare, historically. I am just very happy to be here, and I thank the organizers for the privilege of being here. One of the doctors with whom I work at Scripps Green and Scripps Memorial sent me the link to this conference, and I took it. So I'm really happy to be here. As a doctoral student in bioethics in Rome, and that will be about 15 years ago, I had the privilege of coming to the United States for 4 consecutive summers to have some clinicals at the then St. Vincent's Hospital in Manhattan. There I met Professor Solmesi. I think I heard him be mentioned here today. And so many years after, the hospital closed. But my 4 years with them also gave me the opportunity of actually, dealing with some of the issues that we have raised here today about the role of Catholic health care in a pluralistic, morally pluralistic, society. St. Vincent Hospital, the chain, in the morning of September 1, I was also here in the United States, was one of the hospitals that was pivotal to the care that was given to the victims and their families following the terrible tragedy. And I also know that St. Vincent Hospital has a big outreach to people of very low means in their care. But when I look back and see that St. Vincent Hospital is closed, and they did tell me that it was going to happen, that they were finding it difficult to compete because they were not offering certain services, and so they didn't have the money, and that hospital closes. I just believe that nobody has won, that it's lost for everybody. The reason I say that is in most other sectors, whether it is business, there is freedom, there is space for plurality. Different brands sell sometimes the same thing, but under different brand names, and people are okay with it. Political parties also, they look for power, they exercise power, but they do it from different point of views. But I believe that where you have to legislate everything and make the state be the arbiter of what is right and wrong, it speaks of a certain fundamentalism that is wrong. Because some things in Christian moral life, when you talk about ethics, some things may be legally right. The state has said this is the law, but they will still remain morally objectionable. That's where you talk about conscience. So the law of the state can permit it, but because I also appeal in my conscience to an authority that predates and is higher than the authority of the state, then there is a conflict. And in a lot of the cases, we are bound to respect, the higher authority. That is God. So being able to recognize some of these differences and entering into respectful dialogue, I believe will bring greater good to a greater number of people. But when you insist that it has to be just one way, the same thing you're accusing the church of being, not being open to dialogue, the state becomes, the state also falls into the same problem. That's what I think.
So I think at one point, right, what you said, and actually St. Vincent's is actually best known for treatment of HIV patients, which actually resulted in a major conflict between the women religious who have actually done healthcare and the male hierarchy of the Catholic Church. And the story of Catholic healthcare in the United States is actually one, and we're seeing it even more now, where the hierarchy is increasing control over decades over Catholic healthcare institutions. And it's partly a story of decreasing numbers of women religious. It's partly a story, though, of fewer options and more monopolistic behavior by healthcare institutions. So healthcare is now a big business, right? What it is primarily is big business. Nonprofits are big business. The amount of charity care they provide is approximately equivalent to for-profits. Public hospitals is where you get charitable care. The closing of St. Vincent's in particular is a story of market conditions. Chelsea is one of the extremely wealthy parts of Manhattan. And the physical plant of St. Vincent's was extremely run down. And I used to live right by there. I have been to the emergency department there. It was not a place that people chose to go. I did not realize that when I went. So it's a big business. Now, when you talk about conscience, right, you have to have conflict with the state for you to say, oh, I get to supersede, right? Well, part of the problem is when you're talking about business decisions and setting up hospitals, you can set them up in a number of ways. You have a lot of choices in terms of whether you are setting yourself up for a conflict with the state. So one option would be to have no obstetric care, right? In an institution, this could be a way of structuring care. You could have run a hospital without an emergency department. That's a little bit harder to do, right? But so there's ways in which you can make your healthcare decisions to create fewer conflicts. And we saw this actually, Baptist healthcare, when Medicare and Medicaid came into effect, the Baptist churches, congregations had teachings against taking of government monies because they understood that, Catholic healthcare is financed. Revenues are more than 2/3 come from state and federal monies, more than 2/3, right? So we're talking about institutions that are majorly public in other ways. And so when you have that sort of scenario, the Baptist congregations determined to disaffiliate. They still have the names, they still have Baptist representation on the boards, they have relationships, but they determined that, right, this was primarily going to be a federal program run through what were secular institutions. And that actually, the Catholic healthcare has presented itself as secular in a number of different ways, sometimes more, sometimes less, but engaged in the enterprise of healthcare as their primary mission, not engaged in an exercise of religious association. We could look at other charities that I think look closer to that kind of model at this point.